All right, welcome back, everybody. This is episode 10 of our podcast series, and we're going to get into what are the harsh realities of having a case because, as you can imagine, right, we can't always win. So we're really happy to see you again. My name being Tom James, and we have Bobby Raitt on the line as well. And so we're going to go through some of these examples. And so, Bobby, do you want to lead us off? You want me to lead us off? How you want to do this?
I'll
Because
lead us off.
this is a good one.
It's a good one, but it's also a very hard one for me because, part of being, in my mind, a good trial attorney is being a competitive person. And Tom and I are both very competitive people and we hate to lose. But another part of, in my mind, being a good trial attorney is being able to learn from your losses. And it's also being able to admit it. You hear more attorneys and all they want to talk about is their $1 million verdicts and this and that and the other thing. And Tom and I have our fair share of those. We also have losses because any attorney that tries cases for a living that doesn't admit that they've had losses they're flat out lying to you, right? So we're using this as a chance to tell you how there is definitely losses in this area and that we have taken the benefit of those losses to turn around and kind of learn from it. What did we take away from that after the dust cleared, after the tears stopped shedding, and after you counsel your client? Because that's another big part of it, right? You have a loss, it's your client's loss, right? You feel it as a competitive attorney, you feel it as someone that wants to do right by your client, but the client is the one that had all these hopes, all these expectations, was putting their faith in you, and now they're hurting, and you're hurting even more because they put your faith in you and you lost. And I'm going to talk about one, Tom, and then you can go and we'll kind of switch off because I think we're each going to talk about two. And I would say the first one, and this is probably, I would say, the worst trial result of my career. It was obviously a loss, but it was the fact that I had a case that 100% should have been a winner, and it wasn't. And I represented a very nice woman. She was a master gardener at Tom's favorite college, Michigan State University. So, as a master
Go State.
gardener, there you go, green and white. So, as a master gardener, you can understand she had to get down, she had to get in the dirt, literally, and she had to do her job. And her main injury in this accident was that she had a partially torn hamstring. And I don't know if any of you listening have ever had any type of hamstring pulls, even. They can be very disabling, debilitating. And it certainly was to her. And she went through a ton of treatment to try to get better, as we always encourage our clients to do. She was a very nice person. She was a very honest person. She didn't feel comfortable going through the process of pursuing a claim and then filing a lawsuit against the other driver, but she did because she understood this other driver had insurance, this other driver was at fault, this other driver put her in the circumstance where she had daily pain, she had to treat a ton, and she was disabled from work. And as part of the whole process, she consulted with me early on, and we pursued the claim through what's called alternative dispute resolution, which is other types of avenues to settle your case once you file a lawsuit, other than going to trial being the last step, so to speak. And we went through, and to give you bare numbers, she was offered in a mediation, which is one of those alternative dispute resolution processes. I think it was $200,000. And prior to that time, her case had been evaluated by 3 attorneys in a process called case evaluation. And that case evaluation number was $450,000. And this was all taking place in Ingham County Circuit Court, where Lansing is, where she lived and where she worked. And we accepted the 450. The other side didn't accept the 450. We went to facilitation, and the other side offered $200,000. And we talked long and hard about it, but it was clear to us that her case was worth more than $200,000. So we started preparing for trial. We spent hours and hours and a bunch of time, and I visited with my client. I ate dinner with my client. I saw the way my client was restricted in and out of her home. I talked to her husband at length, her kids at length. Her aunt was there. Her best friend was there. I prepped witnesses. We did the whole thing and we go to trial. Now, one of the biggest contentions from the other side in this case was the fact that with a partially torn hamstring, there was other modalities or other types of treatment she could have undergone other than various treatment protocols she did undergo. And they hired a doctor. The other side hired a doctor to evaluate her. And in his opinion, she was not disabled. This was number one opinion. She was not disabled from the partially torn hamstring. She had two physicians that she treated with that clearly said she was. She did try to go back to work, which we always encourage, and she couldn't do it. And his other opinion, this doctor that they hired to see her, was that there was a couple novel new types of procedures she should have undergone before kind of giving up that she wouldn't go back to work. And we went through the whole process. We're in the trial. We seat the jury. Again, we're in Ingham County. And, we always look as attorneys, what county are we going to be trying the case in if we have to go to trial? And we know from experience and from other cases and from other attorneys that certain counties are a little more conservative than others, meaning that jurors will not consider a case to be as valuable maybe in one county as another. And Ingham County is one of those counties that's pretty conservative. But I had, in my estimation, even today as I sit here, a very good client and a defendant who was not accepting responsibility. And we always look for that because, Tom and I always discuss the best turnout for a lawsuit and then a trial is when you have a villain or someone that you can label as the bad guy and your client looks good. Your client looks like they tried to work. They did everything they needed to do to get better. They're not just sitting home looking for money and that they're deserving of that money. I had all that. But what I had even better than that was when I got the defendant's doctor on the stand, I got him to admit two things against his two opinions. First, that he now believes she cannot do that job as a master gardener because we brought up a lot of things that were in the records of her treating doctors to this guy. And he said, well, I must not have seen that or must not have realized that. And in the end, we always say, don't ask that question unless you know what answer you're going to get. I was so sure he was going to now give us this and turn his opinion of no disability into disability. And guess what? He did. And he almost was apologetic in it. But I also got him to admit this novel medical procedure that he was saying she could have tried was really in the investigation stage. And there was perhaps as much risk to doing it as not. So now I'm sitting here thinking, oh, this is a slam dunk. And we were very happy with the way the trial went. You always look at the way the trial goes. So when I gave my closing argument, I was able to say all they had going in was this doctor. And you all saw for yourselves that this doctor gave an opinion here in court that was against his initial opinion, that validated the fact that my client couldn't do her job that she had done for 20 years and enjoyed. And he said this procedure that he thought she should have undertaken was perhaps too risky. The jury was out for a long time. And if you've watched any of our other episodes, in the area of auto negligence or when you're involved in an auto accident, whether it's a truck, a motorcycle, you have to meet a certain threshold as a plaintiff, as the one bringing the case, and that's called serious impairment. And what serious impairment basically means is that there's an objective component, something you can see on tests or during a doctor's evaluation about your injury, and that it affects your ability to lead your normal life, right? We had that here. I mean, talk about something that affects your ability to lead your normal life. We had an injury that didn't allow her to work her vocation, her job that she had done for years. And we certainly had an objective component. Everyone agreed that she had a torn hamstring. The jury was out for, I would say, like 3 or 4 hours. And usually, once you get there an hour or two, you start to get, anxious, but you start to have confidence as a plaintiff's attorney that they're looking through everything, they're considering everything. I always had some concern in the back of my mind because as a trial attorney, Tom, you look at the jurors, you see when they're nodding, you see when they're squinting, when they turn their head, what they're thinking about testimony, this and that. I just didn't have a lot of faith in the guy that turned out to be the foreman, the leader of the jury, with the way he looked at things, with the questions he answered in jury selection. We call it voir dire. And he turned out to be the foreman. And guess what? They came back after 3.5 or 4 hours and they said 0. they did not believe my client met that serious impairment threshold. It was like, I've had various cases that we get zero on, but this one with the type of client, with the way the trial went, with this doctor that changed his opinion favorable to us, with a very serious injury. Because on average, you listen to partially torn hamstring. Well, come on, I'll never forget the case evaluation included an attorney who was the neutral, the one in the middle, not a defense case evaluator or a plaintiff's evaluator, the neutral. She's like, "Oh, I had a partially torn hamstring, and it was unbelievable." And she went on, and and that's when we got our 450 number because they could appreciate it. Well, this juror who led this jury, I believe they were in there so long because there was a lot of disagreement with this guy. But he had a mission. We hear about it. There's movies made about it. That juror, he had a mission to bring that jury, all 8 of them, he had a mission to get them to not award my client money. There was something about her he didn't like. And to this day, I think about it. I think about it every time I pass an exit down 96 because that's where my client lived over there in Lansing. And it hurts to this day. As far as what I learned from it, the only thing I could take from it, because I'll tell you this too, the clerk to the judge called me the next day and she wanted to apologize. I said, "What are you apologizing for?" She said, "Mr. Ray, I'm apologizing because you just had the case in the wrong county." So what do you mean? She says, "I've been his clerk now for 23 months and we haven't had one favorable plaintiff's verdict yet." And, did I learn something? Would I have not brought the case? No, I still would have brought it. You're going to get that juror. You're going to get that situation from time to time. But the only thing I can say is you got to consider, and Tom and I talk about this, where you're going to file as to how you're going to advise your client. And maybe I should have talked to her a little bit more about that with, that $200,000 I talked about at the facilitation level. Still don't think I would have had her take it, but it's a consideration where you're filing your lawsuit, where you're going to be trying that case, the type of jurors you're going to be trying to convince, and the judge that you're trying to convince. And it was a very conservative judge. So that's probably my biggest disappointment. Yeah.
Yeah, I mean, that kind of harkens back to, before I get into my one of two, that gets back to episode 8, right? So if everyone goes back and you re-listen to episode 8, that's where we have those common questions, and the one that we came out of the gate for everybody, and the most common question, or one of the most common questions, is, what is my case worth? Right. And that gets to that, where there are certain jurisdictions, right? Certain counties. We're using this legal word of jurisdiction, right? There are certain counties where they're more conservative. That's kind of the term we've been using. Conservative, in that it's harder to win in personal injury cases in those counties. And that all factors into our advice and things. And sometimes we still don't agree with it, right? I know exactly what Bobby's talking about, right? Where you get this number and you're like, this isn't enough, right? Even considering the county that we're in and everything else, this still isn't enough for my client. We need to go for it, right? So yeah, I know exactly what you're talking about there. So
I don't like this episode anymore.
I know. It is tough. It is tough because as much as I mean, we like doing these podcasts. I think we're getting pretty good at it, right? We're at number 10 here, and but it isn't all right. It isn't all gold line streets and roses. To get to where we're at now, you had to take some lumps, right? 35 years of practice for Bobby, 20 years of practice for me. I've tried more than 35 cases now, to verdict, right? To the very end, where you're getting a decision, whether that decision is going to be made by the judge, we call those bench trials, or whether the decision is going to be made by a jury, right? Typically, we have 8 or 6 people on that jury for civil cases about money. And so we've gone all the way to verdict and to decisions. And so we learn a lot in that process. And in fact, my first example of one of the, it's going to sound like a win, but I continue to come back to this case because I don't consider it a win, a full win. I think that there were things that I could have done differently 18 years later now, right? It's easy. Hindsight's always 2020, right? Armchair quarterback's always right. Um, but there was a trial that I was involved in roughly about 18 years ago. It was for an older man. He was 87 years old when he was killed. He was crossing the street and a truck ran him over. And we ended up going all the way to a jury verdict. The verdict came back at $2.6 million, right? And and I still to this day consider that to be a loss. I believe that verdict should have been in the eight figures, right? 10 million plus. Because of the way the suffering that he endured prior to passing, as well as his nine children. Right, he had nine children, pretty good sized family, and their loss of their father, who was a very active older man. And in fact, some of the facts of the case really stand out, and I'll never forget. He was an 87-year-old guy who was riding his bike, and he was riding his bike from the Coney Island that he would have breakfast at every morning with the same two waitresses every morning. He would then go ride his bike over to a retirement home where his girlfriend lived. It wasn't the same retirement home he was at, but he would ride his bike, and on his way to go see his girlfriend, that's when he was killed. And so what strikes me, right? What strikes me, and why I consider it a loss, not only because of the money, it's because I learned during this process, right, that juries and general people, um, if their entire focus, right? And I spent my time focused in on his pain and suffering prior to passing. And I'm going to tell you, this was an awful one where he got stuck underneath a tire, and the truck kept driving for another 200 feet while he was stuck to that tire before he passed, and the whole time he was suffering. In fact, I had a witness take the stand, and I brought her up, and she talked about how she saw him trying to push himself away from this tire as he was under it. Horrific facts, horrific facts. And that's where we spent our time, because that's where the focus group kind of told us to spend our time. Oh, that's another thing that we do. And you're going to find that out from about Bobby and I. When we have these serious cases that are going to trial, we will oftentimes do focus groups, kind of like mock trials, to figure out where we should spend our time and our focus. And because sometimes we get too close to things, right? We become friends, we all these other things. It's nice to have these people that step back and tell you where to focus and help you with that direction. But anyway, they told us to focus in on the pain and suffering because it was so egregious. Well, we did, right? And I did. And I brought up the witnesses who were talking about that. We didn't bring as many witnesses to talk about the impact on the family. I only had two family members, two of those nine, right, that came in, and they talked about, how things are different at Christmas now, how things are different at birthday parties, and all of those things. And so in doing so, and the verdict came in at 2.6, I was a little disappointed. Luckily, I had an opportunity to go interview the jury. We don't always get a chance to do that, right? We don't always, but the judge let us go interview the jury. And one of the questions I had for them was, well, how did you come up with this number, 2.6, knowing that he went through all this before he passed? And so one of the things that a couple of the jurors said is, they said, well, we just felt uneasy that the family, right, the kids were going to profit. That's the word they used, profit, from their father's suffering prior to passing. And that was something. And again, this was almost 2 decades ago for me, that I hadn't really considered, that a jury would view it from that angle. But it made sense after they said so. And so all of that time I had spent focused on his pain and suffering prior to passing, um, it it only reinforced what the jury's kind of bias was, that the kids shouldn't suffer from everything that dad had gone through. So what that has taught me, right? That has taught me that obviously that is important, and I do spend a lot of time on the mechanism and the things that the person who passes goes through, regardless of age, right? Whether they're 19 years old, whether they're 87 years old. But the real harm, right? The loss that needs to be communicated and the jury educated, because I don't really consider myself a trial attorney, right? I consider myself an educator. I'm in the business of educating the jury about everything that you are having to go through or this family is having to go through and their losses, because once they understand the losses, that grandpa's no great grandpa is no longer going to be there, right? Great grandpa's not going to be there to go hunting with the grandkids, and do all the other fun activities and the losses of the family. Once they understand that, then they will understand compensation to those people who are missing out on that loved one. And that's really where I spend my focus these days. And I'm going to tell you, it worked out last week, right? So last week, I had just resolved a case. Now it's a confidential resolution, but it's for an 89-year-old woman who was killed in an automobile collision. And in that case, we got a settlement. And that one did not involve a lot of conscious pain and suffering, but I focused on family members. I focused on all the children getting their losses, on their grandchildren, on the great grandchildren, because we're talking, right? 89-year-old great grandmother, and spending time on focusing on that. And that case resolved at almost double what we got from a jury verdict. So yes, I hate talking about these losses or perceived losses as much as Bobby does. But what I really like to do is remember why those cases went the way they did, so that for our next case and for you, we will head down the path that's going to result in the best recovery for you.
Yeah. Your loss wasn't nearly as hard as my loss because you got a verdict. At least you got a verdict. But it's interesting too because that's something that I learned, that issue about the loved ones and their loss of the family member. That I learned through a focus group when the focus group juries were so hell bent on that one issue, and I learned it that way. And much of the time, we learn a lot from those focus groups. It's interesting too because I mean, there's various things I've learned through losses in trial, but I'm going to talk about a loss on a case that never made it to trial. And perhaps I might not have such a what I learned from it moment at the end of the story, but the reason it hurts so bad is because this client was so wronged. And I know Tom will agree with this. The hardest losses are for people that are so deserving and such good people. And this was a client that she was a beautiful woman. She was working. She worked for a company that was contracted out to another company because her company had a specialty that this company needed. So she went to the other company's warehouse where she did her work. And essentially, what she did is she was inspecting a certain car part at the end of the line after it went through all the other inspections to kind of put a final stamp of approval on it. She's sitting at the table at the end of the quote unquote conveyor belt of individuals. And her and a coworker of hers are at the end, and their specialty is this final inspection. That's why this other company brought her in. So she's sitting there, and all of a sudden, her head was pulverized into the table in front of her and smashed. And she had multiple fractures to her nose. One of her eyes her eyelid became detached and fell. And she had multiple fractures of her skull. And what had happened is one of the employees of the company that owned the warehouse, in other words, the company that invited her company to come, he was using a high-low to remove boxes that were stacked up behind this table. And he didn't get both of the forks of the high-low under this very heavy, very large box. And it tipped and fell and caught her head and smashed it into the table. So we pursued a claim, obviously, against this company. We had a high-low expert, we had everything. And this woman, what she went through multiple surgeries. They never could get her nose and her eyes to stop watering and running. It was a constant for the rest of her life. And she went through surgeries, eye procedures, nose procedures, scar revisions, all this stuff. And I said she was a beautiful woman. She was still a beautiful woman, but boy, did it mess up this beautiful woman's face. And through all of it, she was stoic. Through all of it, she was smart. She helped so much with her case, whether it was pre existing stuff we needed or doctor's opinions that we needed. She did everything we asked of her. She asked good questions. She researched legal theories to make sure that she understood them, not to call us and say we were doing the wrong thing. She wanted to be educated on her case because this was kind of a novel area of the law. And I don't have to get into a lot of the specifics, but there's certain law that talks about it's called borrowed servant. And, in the area of construction accident cases or cases that occur with a company who's at fault, in this case, in a warehouse, you can have a workers' compensation case versus a negligence case. For example, if this was an employee of the company who owned the warehouse, in other words, the company that employed the high-low driver, and if my client worked for the same company, she couldn't bring a negligence case. It would have to be a workers' compensation claim. Well, they didn't work for the same company. They were what's called a borrowed servant. They borrowed from another company, an employee. And to the point, the HR department, when they were given information to fill out for workers' compensation, they said, this isn't our employee. She goes through her health insurance. So, we were good. We were going forward. We were doing our evaluations. Long story short, we got to the point where we went to a former judge who did what we call a facilitation, where he facilitates trying to settle a case for us. Very well respected former judge. And we went through a whole day process. There was a very aggressive, very knowledgeable, experienced attorney on the other side. And when it came down to it, the judge, the former judge, the facilitator, decided we were too far apart. He was going to recommend a number, which happens a lot, right? He's going to recommend a number, give both sides a certain period of time to either accept or reject that evaluation. The number he gave was, I think, $950,000. And we always thought this case was probably worth somewhere between $1 million and $1.5 million. So this number wasn't offensive. And there's various reasons for that. There's some risks if we had to try it based on liability and that type of stuff. We had a very conservative judge in a very conservative county. We had a very good defense attorney, but we knew this case was a good case. But this one wrinkle of a potential workers' comp issue and thing was always lingering, was always above us, was always being threatened as something with a motion that they might bring to try to throw the case out. So I counseled my client like I always do. I said, this is what we believe as your attorneys. You have to be comfortable with accepting or not. And she said, Bobby, I'm hearing you, but I really need a recommendation from you because I'm inclined to say that, I don't know what to do. I know that to me, this is a $10 million case, but we obviously know we're not going to get $10 million. So at the end of the day, she did not want to accept it, but we talked about the alternative because that's what you have to do with clients. You have to explain, you accept it and they accept it and we're done. One side doesn't accept it, we're going to trial. And as a part of that trial, we are going to spend a lot of time with you and your family. We're going to spend a lot of time in court. We're going to spend a lot of time on the witness stand. We're going to go through a whole process. You're going to be questioned. You're going to be cross-examined. Your doctors are going to testify. We're going to spend $50,000 in costs trying your case. And at the end of all of it, if the jury comes back favorably, guess what? They can appeal. And if it's a big number, they probably will, because especially to the insurance company and the insurance industry, what's it to them? For our client, and for us to spend the kind of money on appeal, it hurts a lot more than the insurance industry, which is of one, if not the most profitable industry in the country. So what she said is, look, at the end of the day, I can live with that number. If the other side accepts it, I want to accept it. And I said, I think that's probably the right decision. And I was confident because, as Tom and I talk about, when these facilitators recommend a number, normally they're pretty confident that both sides, based on all the negotiations and discussions between them that day, is going to accept. So I'm thinking, okay, it's not this home run we want for this great, great individual, but it's a good number. It's a reasonable number. It's not an offensive number. And it avoids putting her through a whole trial, which would be painful. I mean, she doesn't like the way she looks anymore, this whole thing. And so I thought about all of that in telling her I think she was making the right choice. She accepts it. The other side doesn't accept it. And I called the defense attorney. I'm like, what the hell? And he said, I know, my guy, I couldn't convince my guy. his guy being the head of the insurance company. They were a self-insured company. The head of the company really is who made the call. I couldn't convince him. They want us to file a motion. And I got that pit in my stomach, right? Pit in my stomach. They're going to file a motion on this issue of workers' compensation. Now, Tom and I know some really good attorneys that handle appellate law, that handle appeals. I think one of the best in the country is a good friend of mine, and I called him up and I told him the issue, and he said, "I'd love to meet with you." And we went and met with him, and what we did was we prepared this for to defend this motion that they were going to bring, as if we were going to have to argue it in the Court of Appeals. Because one thing's true of defense, insurance companies, big business, they go to trial, they don't like the number, they appeal, right? They file a motion, they want a case thrown out, they don't get it their way, they appeal. So I had this appellate attorney help us with the defense of the motion they eventually filed, and we won. We won the motion, but it was such a poorly written opinion that when they filed their appeal based on losing the motion, we counter appealed for the basis of what she decided, because it was just wrong the way she decided it. And we thought we were fine. We went to the hearing, this and that. Based on the current law, which is ancient, the Court of Appeals reversed our win in the circuit court and said it has to go back to the circuit court to decide on these issues. And when decided on these issues, the case was thrown out. We appealed to the Supreme Court. They didn't take the case. And I was sick. I'm still sick about it. That's my theme for this episode. I don't like talking about this stuff, because these were both of the cases I talked about, very deserving clients that were wrong from really two different things: a very conservative law that's in place and a fairly conservative appellate court. And then the Supreme Court doesn't take a whole lot of cases in our industry, the personal injury industry. And we were hoping, because there was one very good judge at the Court of Appeals that wrote a separate opinion that said, my hands are tied. This law is archaic. It needs to be addressed by our Supreme Court. But under this law, the plaintiff loses. And we were hoping that the Supreme Court would listen to them and take it up, but they didn't. And it killed me. And a little twist of this thing is that the appellate court, the appellate attorney that I use, his wife is an appellate court judge. And I was like, let's just do it. Let's have this appellate court judge. Let's have your wife call them up, tell them that, they're not going to do that. But I just was so sick that my client had to go through all that. And, my loss in that case was nothing compared to her loss. And that's what I think about on a regular basis. I think about it, I would say once a month. I think about, her name's Julie Boland, and she has no problem with me sharing her name. Terrific person, terrific client, so wrong by clear negligence and a law that was so archaic. So what did I learn? I learned that sometimes you get a case and your hands are tied by certain factors that are out of your control. I think that's the only thing I learned there, Tom. I certainly didn't learn that there's something I could have done differently, because I would bring that case every time, and we had to bring it in the county. We brought it in, and actually a very conservative circuit court judge ruled in our favor for the wrong reasons, but she ruled in our favor. And it was just a bad law that still hasn't been changed, by the way. So if you ever get in that circumstances, give us a call, 866-RATE-LAW, and I'll explain to you that you may not have the best outcome. So we'll see.
Well, we tried, and well, I shouldn't say tried. Like, we didn't go to a trial in this other case, but I had another case that was very similar, because I remember yours. Yours was a while back. And then probably, like, I want to say right around COVID, I had a similar case where it was a forklift driver, and he was injured when the semi-truck pulled away too early from the loading dock, right? And then his high-low tumbles out the back, and he has a back injury. Now, luckily, his injuries, luckily for him, I should say, his injuries were nowhere near as substantial as your client's was. And in fact, he was back to work pretty quickly and stuff. So, but who we were trying to pursue as one of the defendants in the case was the place where he was working, because he was contracted in as a temp employee. But the temp agency had literally had an office in this warehouse where the forklift was working.
Yeah, I mean, it gets technical, but that was one of the things they argued in my case, that my client's company was a temporary agency, and it wasn't a temp agency at all. It wasn't a temp agency. No, they just happen to have a specialty. But that gets into the weeds and is boring for the general person. So we don't have to talk that. Bottom line is there was some very archaic law in a specific area that we don't see a lot of, but we do see some of, and it needs to be changed. That's what I learned. It needs to be changed.
But here's another thing that I don't know, and maybe it's funny about the way that this podcast is kind of, because it's kind of freestyle, right? Yeah, you're throwing in a little bit, I'm throwing in a little bit, but when it comes to talking about these cases where we've learned, right, where we've learned these things, I can tell you we could go on for years about this, where it's like, oh, and furthermore, there was that one situation and that's never going to happen again. And furthermore, right, we'll keep going like forever. So let me go on to my next one. And this one actually it relates to the firm that I came from. So as you've learned throughout these various podcasts that we've had, is that Bobby and I used to work at the same firm for 15 years together, and then he started Rate Law 5 years ago, and I just joined him at the beginning of this year. But while I was still at the last firm, but Bobby had already left, there was a trial that another attorney had attended. And I'll tell you one great thing about what we do as trial attorneys, that we're always learning, right? We're always learning. If I can go watch someone else's trial, I will absolutely go watch someone else's trial. Bobby does the same thing, because you learn from, right, what do people do? And then you also learn, ooh, shoot, maybe I won't do that. Right. That didn't work out. And so that's one of these situations. So this was a very serious case. Two people were killed by a semi truck. And that case went to trial. And the demand, right, the request from the decedent's family, I believe we're adding up all the numbers, and it was a $30 million request of the jury. And the jury came back at $2 million for two people being killed by a semi truck. And so obviously, right, you heard my other story where I was angry about a $2.6 million verdict. Imagine how angry we were as a firm over a $2 million verdict. But that, in my opinion, is a loss, right? That doesn't adequately compensate the family for losing two of their members. And so, but you go back and you start thinking about this, like, how did that happen? Right? How did that happen? And in my own analysis, again, 35 jury trials, right? 35 trials under my belt. I came back to, I believe, right, one of the issues, and what I learned in my takeaway was that they were focused too much on the trucking company and trying to establish and bring in more money into the case. So there's certain layers of insurance and layers of liability and responsibility in trucking cases. And you need to make certain allegations in order to bring in certain parties. And it makes a big difference in the money at the end, right? It makes a difference between maybe $2 million of coverage and $30 million of coverage type of thing. And they spent probably 70 to 80% of their trial all on that issue. Get this certain level of liability. In fact, going through, and I helped go through and look at their PowerPoint. They were using a PowerPoint for their opening statement, and they had 70 pages of PowerPoint. That's a lot, right? That's a lot in an opening statement, but there were only 3 pages about what the family lost and the harms that they went through and everything. And I'm going to tell you, maybe, well, now that I'm saying this out loud, I feel like I'm saying I learned the same lesson in both cases, but it's still an important lesson. That the lesson is that no matter what we as attorneys think we have to focus on in terms of getting, this culpable defendant, this defendant in there, this defendant in there, at the end of the day, every single case is about a person or persons, right? Everything we do, you're not a number, right? You're not a case, you're a person. And your loved ones are people, and they're your loved ones. And so if we as trial attorneys forget that we're trying this case on behalf of what people have lost, not what a trucking company should have done or this broker should or shouldn't have done. But if we lose that focus about the case is about you and your losses, it's never going to result in uh, adequate redress or compensation for what you're going through. And this stuff, I come back to it every single day. Every single new client Bobby and I meet, we just met a new client yesterday, and the first thing that we're going over is, hey, tell us about yourself. Tell us about your family member. Because the person that we met yesterday was also about someone who tragically their life was cut short. Tell us about this person. And once we start learning about them and their family, then we can communicate that. And we, as again, teachers to a jury, we can teach them what was lost. I mean, I can tell you that that is the number one focus that we spend our time on. But it's not something that we read about in a book, right? We didn't learn about this in law school. God forbid if you learned anything in law school, but they didn't teach you this stuff in law school. They didn't teach you empathy, but maybe they should, right?
Yeah, it's
Maybe
funny
they should.
because actually I did learn, we use the term losses, and I actually did learn that in a book. In fact, this one guy that wrote the book that I read, very good book, it talked about, he doesn't use the word injuries. He hardly ever uses the word pain and suffering. He uses losses because that's where the compensation, where the money, where what the jury can do to help comes in. They can help change those losses, and so that's what he focuses, and that's what he uses. But when you were telling that story, and you've told me that story a couple of times now about our old firm and how they tried that case, I always remember what a very experienced attorney told me in the beginning, and that is, the jury's generally going to focus on what you focus on, right? So if they spend all their time, and 67 out of 70 slides in their PowerPoint were about issues regarding coverage and liability, the jury is so focused on that, then when they're asked to give $30 million or $60 million or whatever it was in that case, they're like, well, why? Because there was only 3 page of injuries slash losses. So, it's just another example of what Tom and I have learned along the way. We've done this for a very long time. We enjoy it. We want to represent you. We want to help you, and we want to answer your questions. So this comes to the end of this episode. If you have any questions whatsoever, give us a call at 866-RATE, RAITT, law, LAW, or go to our website, www.firstrateRAITTlaw.com. Thank you for tuning in.